Hey guys, today we're going to talk about a double trust. What the heck is it and why would I ever need it? Before we get there, I'd like to introduce myself. I'm Valerie 𝗬𝘂 of 𝗬𝘂 Law, an estate planning attorney in New York and New Jersey. We provide peace of mind to families through our high client value estate planning and probate administration services. If you are in need of help in either of those areas in New York and New Jersey, we can assist and offer free consultations through our booking website, yourplanningattorney.com. It's really our website, yourplanningattorney.com. And speaking of value, we are here to educate everyone for free. So please ask your questions and share. So hopefully together we're going to help some folks along the way. Now, a double trust. What is it and why do you need it? Okay. When I say double trust, it means that you yourself for your plan need two different trusts. That may sound strange, but let me explain. It boils down to a bucket that is yours, that you still control and use exactly as you did before, but also avoids the probate process. This is the revocable living trust. And a bucket where you've designated someone else as the trustee to manage the assets that you say you only need certain things from, and for all intensive purposes, do not plan to need or want access to the principal of the asset. And I'll explain that in a second. But prefer that no matter what happens in life, as long as you've put these assets sort of out of your control, naming someone else as a trustee for a significant period of time, a particular period of time, that nobody's going to be able to access and touch those assets, and they will end up in the hands of your family. Now, why would we want to divide and conquer? So I have seen before where attorneys would suggest, hey, why not? You're getting to the age where you really should insulate your assets and place them out of your control, right? In this type of irrevocable, what we call asset protection trust. However, the key is, as I mentioned before, the goal there, or the intention there, I should say, not the goal, but the intention is that you yourself don't have access to the principal. So let's say you have $200,000 you're going to put into this account, right? Because you say, I don't really need this money. I haven't touched it in years, right? Well, that $200,000 is meant to be there for the later, whoever your beneficiaries are. Let's just say the later generations. However, if you put all the eggs in that basket, right? And it's not just 200,000 you haven't touched, but it's all of your liquid assets go in there and everything else you own. Well, what if you end up needing or wanting those assets? Because it is an irrevocable trust, it is harder, not impossible, but harder for you to get that principal back to you without losing the benefits you originally created it for. So why would we do this, right? We don't want to overfund that, because it's my belief, at least, and I tell this to every client, that you, as the person who earned all of these assets and created this net worth, should be able to live your life the way you choose to, without hesitation and without lots of hoops to jump through to be able to do so. So I'm a little more conservative and would suggest you keep that second bucket for the assets for you to live your life. Estate planning 101, right? Travel, improve your home, get things that you need for yourself individually. Those things are really fulfill your lifetime, and we don't want to take them away from you, even if closer to the end of your years, you end up spending some of it for care-related items. It's okay as long as you've been able to live your life. And if you're implementing the double trust, where you have some protected for the future generation, you've done your part, a big part of that. And so your beneficiaries should be happy and glad that you've done so. I'd like to mention one more little piece about the irrevocable asset protection trust, okay? Because the revocable trust is just you in a different title, right? Everything stays the same except for the title of those accounts. The family avoids a probate with them. There's a bit more flexibility and protection that can be built in. But the irrevocable, the asset protection piece, right? That's the second trust, right? We get double trust. This is your protection piece. There are states where you as the creator can have some availability of what's under that bucket, under that umbrella, in the bucket, under the umbrella, whichever way you want to talk about it. By that I mean, so I'm licensed in New York and New Jersey, right? So, and I'm specifically talking about long-term care concerns and potential Medicaid use because that's a major concern of a lot of folks. In New York, you are able to receive the income from that type of trust, the protected irrevocable trust. So using our example from before where you put $200,000 in, if that $200,000 is invested and there's interest and dividends and things that are growing out of it, you as the creator are able, if it makes sense, to receive that income. And it will not impact the protections you are building in the look back period you are starting for those assets, having placed them out of your control with a separate trustee. However, that's not the case across the border in New Jersey. And where I work and live is really only 10, 15 minutes down the road, not even. So things can change state by state. That's why it's important to speak with counsel in your area. Again, 𝗕ecie když'𝘁 of 𝗕cie Law, where we provide peace of mind to families through our high-value estate planning and administration services. If you are seeking some help, you can reach out to us for a free consultation at yourplanningattorney.com. That's yourplanningattorney.com. And we hope that you've learned something new here today and choose to share. And as always, take care.